in-depth one than like the usual ones we go to because it's a O1 extraordinary ability visa case, but at the same time, it was also an EB1A and both got approved. And it has to touch on dual intent, which I know if anybody who knows about O1, you cannot really do, but why is that? Let me explain and how in this case it actually did work. So O1 EB1A, a double, triple kind of success story that we want to go through. And then we want to go into talking more about adjustment of status. I know we already spent so many videos and so many live sessions talking about it, but there's just so much misinformation out there, including from attorneys, which I'm not happy about. But at least I want to go in depth to talk more about it, and so everybody could be on the same page, right? And of course, as always, feel free to ask questions. Galen's here with me. Any questions you ask on TikTok, on YouTube, on Instagram, on any other channels, he will see it and then he'll read them to me and we'll go ahead and answer it. So, as always, we're going to start with the news segment. And for anybody who doesn't know, I'm going to catch you guys up really, really fast. It's on the adjustment of status memo that came out on May 22nd, essentially saying if you want to do adjustment of status in the United States, you really should argue and prove that it is an extraordinary circumstance as opposed to going back to your home country to do the adjustment of status at home, at the consulate or embassy. Traditionally, in the past 10, 20 years, 30, 40 years, that has never been a requirement, right? It's just really choose to do it overseas or choose to do it here. They're both the same. And you never had to do this additional argument. But this memo came out and it caused a lot of concern. And then, just last week, we're seeing news outlets and memos, not memos, actually, just news outlets saying, oh, Department of Homeland Security, and they're walking back this memo. So this whole thing got canceled. Don't worry about it anymore. And you see people on TikTok, you see people on USCI, YouTube Short and other YouTube videos, I'm sure, saying like, oh, okay, don't worry about it anymore. I want to really dive into that a little bit more, right? There's just so much about this and I'm dealing with it every single day. So let's talk a little bit about it. So the first thing I want to address is this quote unquote walking back the memo situation. The first thing is there's no official memo from USCIS saying that. A spokesperson saying it is nothing like an official memo that came out. So until and unless there is a formal memo saying they are walking it back and canceling it, it is not walked back and it is not canceled. So take that news with a grain of salt in the sense of you don't have to worry about it anymore. It is very much something that you need to worry about if your case is already weak. So if you watched my previous segment on this particular memo, whether on our Making Immigration Better channel or on this channel on YouTube, if you have a strong case on why you need to do adjustment of status in the US, a short argument should be fine. That's not something to worry about. But if you have a weak case, you came in as a tourist visa, you overstayed, you got married, you filed adjustment status, you have every reason and intent to go back to the US, to your home country, and then coming back, well, this memo can still harm you. So still prepare a good argument. Just because USCIS will have walked back a little bit, it's not official, right? There's a lot more I want to cover, but I see questions are already coming in, so I'll go ahead and answer some of them.
Okay, we'll answer a few questions and go back to talking about AOS. Do you think it's still worth it for AOS for a parent of a U.S. citizen overstayed by 7 days, no criminal or overstay in the past, several times have traveled in and out of the U.S. previously?
We just yesterday got 2 cases approved. Child petitioning parent, tourist visa coming into the US, adjusting status, interview waived. Obviously, no interview, so no questions about this memo. The whole case adjudicated approximately 7 to 8 months. Filing I-130, 45. That just happened yesterday, right? And I was like, oh, that's really interesting. I'll share about that. That was Gabby's case. I don't know if we're going to do a success story on it because there's not much more to say other than that was the case and it happened and here's the facts, right? Um, Now you're saying, well, filing now versus 6, 7 months ago is a very different time. That's true. Is it worth it to file if you have a good case? If you have a strong case that you can argue why the parent couldn't go back to the home country, shouldn't go back to the home country, already overstayed, need to file now, why the children really need them in the US for XYZ reason. There's a national interest, right? Just because it's a family base doesn't mean there's no national interest, right? Plenty of people have good careers, good investments, important things to do on their own merit other than just their petition merit, right? And so, you can make an argument. And so if it's a good case, I would still do it.
And is that kind of your attitude to a lot of AOS recently? As in, like,
If you have a good case, doesn't matter if it's adjustment of status, consular processing, non-immigrant visa, citizenship, green card reentry, it's worth doing. And what does it mean by a good case? Another client has asked me that again and again. Like, well, what do you define as good? Is it very subjective? I think try to do subjective and objective at the same time, right? So first of all, what is the category? What is the request? What is the petition that you're seeking? That request, do you fall within the guidelines? And on top of that, do you have additional things that makes a human being that works for the government want to approve you? When you combine all of that together, right? You take a holistic view of your life from your education, your work, your contribution, your assets, what you intend to do, what you're going to do. You look at everything as a whole, and then you're asking for one small part of it instead of just looking at that sliver. Oh, I meet the requirements, and therefore I should definitely get whatever I'm requesting for, whether it's expedited request, whether it's a green card, whether it's a visa, whether it's a waiver. Well, holistically, do you look good? And the request, do you fulfill the requirements? If all things considered, lots of positive factors overweighing negative factors, you should be able to get it, right? And that's my attitude always, right? For the past 10, 15, 20 years that I've been here at the firm, right? I mean, I've been here at the firm as an intern since like high school. And so, that's what we have been doing. And that's what we really recommend.
yesterday, I had an asylum interview for 485. They said, interview is complete. Now your case must be reviewed. What does that mean?
That just means what USCIS is doing these days, right? A lot of cases, doesn't matter if it's N400 citizenship, if it's adjustment status, a lot of cases are just being reviewed even after the interview. We saw a case, it was like a marriage-based case, and I think it was still being reviewed, I think 15 months after the interview. So it's extremely long, but the case is already done. It's already interviewed, right? And so the recommendation is to wait a couple more months. If it exceeds, I don't know, they waited like 7, 8 months. I said, wait until the 12-month mark. They still haven't made a decision, then potentially do a mandamus.
I'm a healthcare worker studying my master's. If I pursue a doctorate, is that a positive factor for AOS?
Yes. High education, high work in an industry that's needed in the US, all three positive factors.
If any green card holders need to go to the psychiatrist and get medication and therapy, will this negatively affect their naturalization, their future naturalization? Will it go to the records?
Yes and no. So I guess it's a maybe, right? So, but I just hate the word maybe, right? I mean, in law school we're taught, there's books about it. Like you start with maybe and you analyze everything, and then in the end it's like, okay, well that was useless. So I really don't want to say maybe, but in this case, like let's analyze it, right? So you're asking about N400 citizenship. On the citizenship application, there is the analysis of good moral character. And on the good moral character front, now they are considering your education, your income level, etc. Mental stability, criminal record, that is not one of the things that's listed in the good moral character analysis. But if it's on your record, for example, if somebody have called the police and you've been detained at the mental institution for 2-3 days and you had to see a psychiatrist report to be able to let out, that's going to be on your record that they're going to see, and that might feed into the good moral character assessment from an N400 perspective. It's not in the memo, but that is what USCIS could see. Obviously, if you are in a civil or criminal matter and you had to use a psychiatrist to prove that you were mentally incapacitated and so you couldn't make you shouldn't be held liable for the choices you made, you didn't fulfill the mens rea requirement of a crime and therefore you were let out. Well, yeah, maybe you weren't convicted, but does that influence the N400 application? So that's the part where we want to talk about more. If you're talking about in the adjustment of status application, you're getting a waiver and you see a psychiatrist report and you're saying you're extremely sad and you're depressed because your wife is going to go away, that doesn't really negatively impact the naturalization front, 4 or 5 years later, because all you said is, I really love my wife or my husband, right? So it depends on what kind of psychiatrist report. Hopefully that helps.
Not criminal issue, just getting mental treatment. Like just outpatient, see a therapist a couple times a week or, etc.
Really want to explain what and how. The attitude towards psychiatrists and psychology is changing in this age, right? I have so many friends who are psychiatrists, people who are doing family therapy, people who are seeking therapy. I personally am a big believer in premarital counseling and marriage counseling and things like that. So I think it's going to ultimately depend on what kind of help you're seeking and what the attitude of the officer is. Again, I have not seen any memos by USCIS talking about this as a negative factor. But if it's a situation where it's tied to again, civil criminal situation, then it could be a negative factor.
Assuming it, never goes criminal, would the USCIS officer even see it if they don't include it in their filing?
So if it's not in a civil or criminal case, they probably can't see it.
How about K1 fiance visa? Both AOS, with the AOS memo, and they're also part of the 75 country immigrant visa pause, so they can't do consular processing.
Right. So if you already got the K1, congrats. I didn't know that was still a thing, but if you got it and then you're in the country, I would totally file adjustment of status. No doubt about it. And I would totally argue the 7500 ban, I can't go back. That is a legal reason. That's one of the things the officers are asking, right? 4 questions. Why are you doing adjustment of status in the US? What's so important that you need to do here? Why didn't you go back to your home country? Is there any legal reasons why you cannot leave or any legal reasons why you are bound here? And if there is any natural interest that we should consider, the positive factors, right? So 3 and 4 kind of the same. So the 4 key questions. 75 country ban, that is totally a legal reason why you couldn't go back or you shouldn't go back.
Is it a good move to is it good to move to an immigration-friendly city if I receive the NTA after motion denied?
The officers see that. They clearly see through that. And the only way to answer this question well is that in your case, you're really saying, my case is already denied. I'm trying to flee the government, right? Your case is already denied, unless you're talking about appeal, which that's fair. But whether you're trying to flee the government or trying to appeal, choosing the jurisdiction that's best for you with the highest chance of success stuff obviously makes sense.
We filed under EB2 from India. Priority date is September 30th, 2014. We now have green card EAD for 5 years until 2029. We're pending 45. So how will this AOS memo affect us? Filed under EB2, India, have EAD.
Right. So your situation is very similar to all the other people who are on H1s and L1s and different people who are like F1s who've been here for a long time. And the argument is, I've been in the US for so long. I've committed everything here. If I were to go back, it is not just to save, a plane ticket or an inconvenience. I would lose my job. I would lose my investment. Somebody needs to feed my dog or cat or goldfish. There's a lot of things at stake. and my job needs me, and my family needs me, and my community needs me. So I think in your situation, you have a lot to argue, and I think it will be fine.
If okay, um,
How on point, all of these questions are all related to the adjustment of status memo, right? A lot of times we stop because we have to take all the other questions, but this is all related to adjustment of status. And some of these questions are actually better than some of the, quote unquote, misguided info that we're seeing. So I really appreciate these questions.
yeah, that's great. It's coming from tourist to F1 to EB3, a negative factor for on this AOS memo.
Great. Let's talk about it. If I were an officer reviewing this case, I see you came in as a tourist, you changed to a student visa, and then you changed to EB3, and presumably you stayed on a student visa the entire time until priority is current, then you filed, right? And so now they're going to holistically take a look at it. Well, why did you come into the country in the first place? What did you fill out on the DS-160 when you got your tourist visa years and years ago? And then your travel pattern, and then you came to the U.S. and what have you been doing? How have you been living? How have you been funding yourself? What have you been working illegally? Have you not been working, but you were able to use your savings? So, given that fact pattern, a tourist to a student, you really wanted to study, you love the US, you love the things that you're going to learn, and then it advanced your career, so you got your EB3, skipping the H1B even, right? And so now looking at that, does the officer believe EB3 is real? Does the officer believe you really need to stay? Why couldn't you have gone back? And what are you doing now? Obviously, you're not the same as somebody who just came in as a tourist and then just immediately filed. You were here already for 2-3 years, at least, right? Potentially even 5 or 6 or 10 years. So, given that background, you probably built a pretty strong base in the US, your home, your car, different insurances, and things of that nature. So, as long as you can really demonstrate, again, going back is just not an option. You have too many important things that you have to handle here. It is in the US's best interest to let you continue to adjust as opposed to break this and then go back. I think you'll be fine.
Because it's a main concern that the officer would think that they lied on coming in as a tourist or lied as an F1, that they had immigrant intent.
The purpose of this memo is to remind the officers that they have discretionary authority to adjudicate on a holistic level. So more than just the basic requirements of adjustment of status, they can weigh positive and negative factors, giving the officers one additional reason to deny cases. So if they have a strong case, they don't have that many negative factors. This memo shouldn't be one where the officer would use to deny cases. So in this situation, if the EB3 is a good company, good application, good labor cert, this applicant has a strong resume, and no violation of their immigrant status. They went to school, they paid tuition, they went to a good school, they had good grades. It didn't look like they were just buying their status. If they didn't lie on the DS-160 and then they got DS-160 tourist visa years ago and they came back and forth and there was like a legitimate reason to transfer. If everything kind of looks right, there's not a lot of red flags. The chances of the officer looking at this entire ordeal, the client has spent almost a decade potentially in the U.S. paying tuition, paying attorney fees, paying for house and mortgage and rent, and now finally able to get a green card. If everything looks neat and good and potentially beneficial to the U.S., denying the case and forcing the person to leave is probably very difficult for the officer. But if it's a bad school, if it's a bad company, if it looks sketchy as a whole, the person's bank account, tax returns, all sorts of things just doesn't quite line up, there's too many question marks, it's easy for the officer to say, you know what, based on my discretion, I recommend doing the consular processing.
Call-in letter for signature and document review. What does it mean?
Call in, say it again?
Call-in letter for signature and document review.
I don't know. Yeah.
Can you still do it, adjust status, if you overstayed your student visa and got married to a U.S. citizen?
Yes. So legally, you can. So the question becomes, the officer will ask you, why don't you just go back to your home country, right? And the answer might be, if I leave because I overstayed, I have to file a waiver if I leave the country, and that could be many years. And there's a lot of risk and cost to the separation, and this will cause extreme hardship on my spouse. So, in other words, in the past, if you were a tourist visa that overstayed and got married and filed adjustment status, if you are an F1 student, international student, overstayed and filed adjustment status, you technically, legally, under 245A, did not have to file a waiver because by virtue of marrying a US citizen, your case can get approved. Tens of thousands of cases have gotten approved over the decade because of this, right? And that's fine, that's in the law. Now, with this memo, it indirectly almost forcing everyone to have to file a waiver, even if by law you don't have to. What does that mean? Because now you have to answer the question, why don't I leave the country and file consular processing abroad? Well, because if I have to do that, I cannot use the 245A, and now I have to file a waiver overseas, and that will be extremely painful and devastating to my marriage and to the US citizen. That's essentially a waiver argument. So without formally forcing everybody to file a 601 waiver, now this is indirectly making everybody do it, or at least come up with the arguments to do it. Now, you don't have to spend the same amount of effort because it's not legally required, nor is it in their policy memo. Although I do suspect in the future, let's say 6 to 9 months from now, they might put it in the memo. And we always recommend all of our clients who are filing in this state to do a mini waiver. But anyways, that's the general idea, right? So if you're in this situation, look up what a 601 waiver is, have ChatGPT help you craft up a mini argument. And I would recommend doing that with your application, whether you build it into the application or you bring it to the interview.
I have a I-130 case being actively processed, reviewed after interview for 140 days. What can I do?
Keep on waiting. Once you find it unacceptable, use Emma to push them, find a tier 2 officers to push them, find congressional help to push them. If it's after 1 year, maybe a mandamus action to sue them to adjudicate the case.
My husband is about to complete a 10-year perm in Mexico. Can I file 212 now? He had I-130 and 601A approved.
Great. I don't know off the top of my head. Gabby would know. She does all the 212, 601s at the firm. But yeah, I just don't know the timing of it.
Yeah, if I missed your question, sorry about that. Feel free to just type it again. I filed my I-130 in February, and my interview has been scheduled next, and I'm very nervous. Any tips?
Say it again.
Filed I-130 in February. My interview has been scheduled for next month. Yeah, for next month, and I'm nervous.
Good for you, because you don't want to take it too easily because you might say something wrong. So transform that nervous feeling into the feeling of excitement. It's the same sensation, and prepare well for your case, right? You know, everything that the officer wants, go above and beyond, right? Proving it. So it's good that you're taking it very seriously.
I came to the US on a K1 visa in April, got married a few days after, and submitted 45 and 765 in late May. Will this memo affect my case? And how should I build positive factors when I can't even work?
Great. This memo doesn't really apply to K1s, you know. I mean, the very nature of K1 is to come into the US, get married, to file for adjustment of status, right? So it would be very bizarre. And you know what? If your case gets denied, right? I'll put this out there for you. If your case gets denied because of this memo, I'll take this case pro bono to sue the government. Okay, that's a promise. But I just don't think that will happen. It's crazy. It'll be so crazy. And I could probably find 10 attorneys that want to join in on this lawsuit. Anyways, I digress. How do you build positive factors? There's so many things, right, other than work. Your goldfish, your hobby, your neighbor, your local library, your volunteer read books to kids. you know, create a YouTube channel, get into photography, you know, take Coursera courses online and improve your education, you know, online certificates, create an AI agent and post about it. You know, there's endless amount of things to be a good human being in this world, despite what USCIS have written of what they consider positive factors, right? Because at the end of the day, it's an officer that's sitting in front of you adjudicating this case, and that human being has their own preferences and their philosophical beliefs of what does it mean to mean a good human, and they might completely disagree with the memo, just like you disagree with the memo, right? Grades are not the most important thing, and so what are other things that can really demonstrate your value? Live your best life. That's usually what I tell all my clients. If immigration wasn't a factor, what does it mean to live your ultimate best life? And show that to the officer. Now, hopefully, your version of best life is actually objectively sound that most people agree on. Like if if your best life is just a couch potato, or harming people, that's probably not good, right? But there's a lot of things other than work that you can do.
Military husband out of state can't attend interview.
Mhm.
Sent memo
Yeah.
orders. Do I go alone?
Yes.
If you are issued an NTA for removal, you have no ties. Is it best to go to court or self-deport?
I'm assuming you mean equity. So if you got an NTA, you have court, you know you're gonna lose, you don't want to be detained, there's so many other things that's in your way. You don't have equity to be able to convince the court to somehow reevaluate your application. Is the best idea to self-deport or go to court? I would recommend self-deport and then prove that you've already self-deported to close out your case. Because if you don't go to court and you just merely self-deport, there's still going to be a removal order in absentia in your removal case. So in the future, if you want to apply for any tourist visa, non-immigrant, immigrant visa to come back to the US, it will be really bad, right? Maybe unless you feel like, you know what, I'm just never going to do it ever again. So I don't even want to spend the time and effort and money to close out this case, right? We did a separate success story video on this, I think a month ago. If you ever have the intent to come back to the US, it's really recommended that you close out the case appropriately. But you could do it by self-deporting and then just appearing and say, I already self-deported.
I entered the US in 2014 on a visitor visa, got married, obtained a conditional green card, left the US 4 years later before applying to remove conditions on the green card.
Okay.
I obtained a permanent unconditional green card. I am still married to the same spouse and continue to work for the same company I worked for while living in the US, and my parents have now moved to the US as well. Is there any possibility for me to re-enter the US and regain LPR status, or would I need to start a new immigration process?
Great question, very complex. The answer is yes, there is a possibility, and I want to dive into it right now, right? It's so interesting. We've definitely seen cases that's worse than yours. Person have left, green card expired years, I think 4 years expired, 2-year green card. We file a late 751 waiver to reopen, to remove the condition and to get the 10-year green card. By purely filing the late 751, and that was a 751 waiver too, meaning they got divorced. In your case, you're not even divorced. Filing a late 751 waiver, we went to talk to the customs officer to see if they can let this person in. The officer said no, but then once the case was reopened, then there was a wiggle room. The officer was still not inclined, but ultimately still let the client in. Came in as a green card holder, then went to the interview, then case got approved, then got the 10-year green card. So in a situation like yours, where the case is so much worse, right? Divorced already, late filing, all sorts of stuff. they still came back as a green card holder and then got the 10-year green card. So if you look into the regulations, there's no exact time limit on when you need to file the 751 waiver. I mean, as in they recommend it, but late filing is accepted. And we did a case, we filed a late 751 waiver, I believe by 15 years. This guy got married like 4 times, more than that maybe. But anyways, got his 2-year green card from the first spouse and then divorced, married, divorced, married, divorced, married, but never bothered to get the 10-year green card because just in the U.S. never bothered to leave. Now, again, married to a U.S. citizen, late filing 751 waiver, and we were able to get that green card. We also did this story on YouTube a few months, I forget how long, but if you search 751, you'll probably find it. So in your case, it's totally possible with a caveat of the officer might really question, well, what were they doing abroad? Did you abandon your green card? So you have 2 issues that you're battling with. So I want to just say it's not impossible. However, the path of least resistance, the simplest solution might be to reapply I-130 and consular processing. Just putting it out there. The easiest path, least friction in the sense of just going through the process again, might be doing that way. But going to liaison with the customs officer, getting the documents, filing with USCIS, and then executing, it's possible, right? It just might be hard, but it's possible. But if it is possible and you do successfully do it, then it's actually ends up easier on you in a sense of, you just submitted documents and then you just fly over and then we cross over together, right? So, hopefully that helps.
I've been here since December 2025, married with US till May 2026. I-94 expired in June. I might have to file my AOS after my I-94 expires. Is that okay if I have all my documents, 7-year relationship, or should I apply for forgiveness?
If you mean forgiveness, you mean a waiver. Technically, you don't have to because of the 245A exception when you're married to a U.S. citizen. However, because of this May 22nd memo, it is recommended that you prepare a mini one, at least to convince the officer why did you overstay and why are you choosing to do adjustment status in the U.S. as opposed to going back to your home country, right? So, to answer your question, if it's absolutely critical that you stay in the U.S. to file for adjustment of status, go for it. Prepare the waiver. A mini one, but at least prepare one. Or go back to home country and do the consular processing.
How long is the I-140 process? I've been waiting since October 2024 for regular processing. Is that normal?
Yes. For a lot of the I-140s, it is. At our firm, we recommend 99% of our clients to do premium processing. It's not too late to do it now, but you've already waited so long. So, the only reason why we don't do premium processing is for like Child Status Protection Act, CSPA. But generally, almost everybody else, we always push for premium processing.
Can you get a work permit if your 485 is admin closed?
I don't believe so. When USCIS admin closes a case and they give you the closure, they usually say your work permit is also terminated. If my memory serves me correct, because I've seen a lot of them. So I believe that is the situation.
Just saw minutes ago the new regulations from DHS on work permits for people with deferred action. Have you heard about this?
Nope, haven't seen it yet.
Okay. Maybe that we'll talk about next week.
Right.
This is the downside. I feel like every Thursday something happens in the morning, some immigration news.
Right.
After my interview, the embassy requested for affidavit that we already submitted. How long will they take now?
It could be anywhere between 3 months, 6 months, 1 month. I mean, they just take their time. There's no standard.
Okay, I don't speak Spanish well enough to understand this question. Do you speak Spanish, Joseph? I always forget.
I took 2 years of Spanish, but I don't. So, but whoever's writing it in Spanish, highly recommend help us Google translate it and then put it in the chat again.
Kualantan argument for adjustment of status. Is that how long? I'm not sure.
Yeah.
Can I travel with an asylum-based green card and my passport without refugee travel documents?
You need a wait. Did they say they have a green card or no green card? If you have a green card,
Yes.
your green card is your travel document.
Mm.
So if your asylum cases have already been approved, you have a green card, that is your travel document. But I wouldn't recommend going back to your home country unless it's been a long time, and you still need to provide a really good explanation as to why.
And yes, you can DM us your questions.
Yes, I mean because of obviously private concerns and
Mhm.
security concerns, it's just that we don't see it as fast,
Yes.
and we might have to save it for the next week, right?
Yeah.
And also, just for everybody to know, if you have questions but you missed out on the live, you can also just DM us, and then we'll save the question and we'll ask it the following week when we do these live.
We'll do our best.
We'll do our best. We'll do our best. Yeah.
Filed I-130 with open asylum case, and they detained my wife after we did that.
Dang. We don't do asylum at the office, so I would really recommend asylum attorney to help you try to bail them out.
Is it a good idea not to apply for naturalization now and wait till circumstances approve?
No. My blanket statement to that line of reasoning of trying to time the best time is usually no. The best time to have applied was 20 years ago, right? 10 years ago, 5 years ago. The next best time is now. I really don't recommend timing different things because there's too many factors you can't control. Who's to say it's not going to get stricter in the future, right? The officers now that are adjudicating a lot of cases, they're still from people who got hired 4 or 5 years, 10 years ago. Officers now that are being hired will probably be here for the next 5, 10, 15 years, right? And then if things are getting stricter and stricter, new laws, new policies, it might become harder. So if you have a good case, make your case better. If you have a weak case, make your case better. In either case, do your best. It's very rare that I would say, let's really wait and find a better timing. I mean, in those situations, it's probably because of the case is so weak. It's just like it's not even worth trying in any administration. So you really just need a new law that will help you.
Our I-130 got approved, but our 485 got annoyed. We're
Yeah.
doing the waiver with our lawyer. Any advice or tips?
Noids are not impossible to overcome. We have seen so many noids get reversed. Usually if there's a noid, it's the officer has seen something that's they can conclusively think that your case deserves to be denied, such as, like, hey, you didn't even get divorced the first time, so you don't qualify for the marriage the second time. So that's a straight up, you don't qualify, period. So I could issue the noid. You don't have to give you the 3 months. So focus on that one critical fact. And also at the same time, really discuss plan B.
How long is the wait going to be for the adjustment of status and marriage?
I mean, we have seen some recent cases that we filed within a year get approved without, well, it's a sibling one that got, it's a parent one that got waived for the interview. So, I mean, for marriage ones, I would usually estimate 9 months to a year.
Oh, okay. I don't think this was Spanish. I entered the country through Kualantan and married to spouse, U.S. citizen. Can I adjust status?
I entered the country through
Kualantan.
Okay.
Does that sound like something?
I don't know. Yeah. And then what?
Then married to spouse, U.S. citizen spouse. Can I adjust status?
Okay, so if you entered with inspection at a U.S. port of entry by a CBP officer and you got an I-94, then you can file adjustment status under 245A. So I'm not sure what that noun is that you're referring to, but it has to be an official port of entry CBP officer with an I-94.
Oh, matter of Kualantan refers to someone who's waived through a port of entry by a border official, and they have been inspected and admitted.
Oh, okay, great. So if you've been admitted and you can prove that, then you qualify for 245A and you can file. But this new memo will argue, well, why here and now? Why not go back? And you have to argue, well, because overstayed, etc., and now I have to file a waiver abroad, and it's going to be detrimental to my spouse.
Thank you for clarifying, Luis. Is it normal to have had an interview for AOS K1 in April, still haven't received the card?
April, 2 months from now, I guess.
Oh, April 2025.
Oh, that's a long time. Yeah. I mean, we have seen some cases the work permits hasn't been approved for 15 months and we had to sue for it, right? So USCIS is just so backed up with like all of these things. So I mean, it's that does sound like extremely long. You know, in years past, they just gave up on all the work permits and just directly issue green cards. So I mean, hopefully that's your situation, but I wouldn't read too much into it. I think they're just behind.
We got interviewed for I-130 and no news. Been 35 days.
That's 35 is very short. We had a client who was waiting for 8 months already.
Yes, okay, thank you, Enrad. It turns out the question was not in Spanish, just Quelantan, vaguely sounds Spanish. I filed for I-751 individually. Is it guaranteed to get an extension without proof of separation?
If you file the 751 or 751 waiver, I have not seen any straight up request for evidence, noids, or denials without the extension. So you pay the fee, you fill out the form. Unless you fill out the form wrong, it gets rejected. That can happen, but just file it again, right? But once they receive it, they cash it. There's a high chance you just automatically get the notice. I haven't seen.
With the FRP in a preliminary injunction, can I still apply for 485 with a current visa?
I don't know. What's the FRP? FRP injunction. Some sort of court case injunction, but yeah.
Maybe about one of the 39 country ban?
Maybe.
I'm not sure.
Right.
Can you leave the country having a final order of deportation?
Can you leave the country with a final removal? Yes, that's the whole idea. Maybe your question is, once you leave, can you come back? That becomes a very detailed analysis. Yeah.
My visa's expired, and my driver's license expired in August. Can I fly in-state while pending adjustment of status?
If you have a H or a L visa, you can fly back to the U.S. and because you didn't abandon it. But if you have a advanced parole, that will also allow you to fly back. But if you don't have an advanced parole, you don't have a H or L visa, and you left the U.S. while your adjustment status is pending.
I think they're in the U.S. They said in-state.
Oh, you're just flying to a different state? Oh, yeah, that's fine.
Even with expired visa and expired driver's license?
Maybe your question is, my visa expired, my driver's license expired. Will the airport allow you? Is that your question? Because of real ID law? I don't know. I haven't seen too many issues like that. I thought now you could just pay a fine, like 100 something, and you don't have to have a real ID. But you also have your passport, right? And so that's an identification that airlines accept. So I think more likely than not, you will be able to fly. If your question is, during the airport, domestic airport, TSA agents will notice that your visa is already expired. Will ICE be alerted and will you be detained? But you have a 45 pending, so if you carry that with you, most likely you'll be fine.
Currently awaiting 221G processing, admin processing in Mexico. How long will that take?
It could take 6 months to 9 months. That's what we see.
Currently married, F1 visa, out of status, married to a U.S. citizen. In February, had a baby in November.
Good for you. Congrats. And that would definitely be a very strong proof to the officer on why you cannot leave the country. You don't want to abandon the baby, and why if you do leave and the spouse has to care for the baby alone while taking care of everything else in the house would be extremely hard, and it proves bona fide marriage. So it's really good for your case. Just don't. Miss your appointment, right? It's hard to be organized with all the chaos that's going on, but prepare everything well, go to the interview well, and have a lot of energy that day.
What are the chances to apply for my husband's green card? We have a child together, been together 6 years.
That is a very strong proof. But I suspect there might be other things that you're concerned about because if you've been together for 6 years and you have a kid, that's such a strong proof that you should have filed years ago. So what other negative things is holding you back, right? And you want to overcome those really well. Sometimes it's not just bona fide marriage, right?
Oh, FRP is family reunification parole. So with family reunification parole in preliminary injunction, can I apply for 485 with a current visa?
I don't know. I don't know this issue well enough. Yeah.
How long will naturalization take now from filing to oath ceremony in LA?
That's hard to say because, even last year they were still doing day of oath certificates. But now we have seen even after the interview, they wait a couple months before approving it, and then after approve it, they have to pass it on to the court, and the court could take 2 or 3 months. So because of that change, it's really hard. But this is what I usually tell clients: between filing to the interview, we could say anywhere between 6 months to 9 months. We have seen some that are faster, like 4 months, but if you estimate 6 to 9, it's safe. And then after the interview, give them about a month to normally do the background adjudication for secondary adjudication. We have seen some get approved within a week or so, but it's definitely not as fast as day of. And then oath ceremony could take another 1 month to 3 months. Now that's on the long end. Now, I mean, not even the longest. In the past, there have been situations where after the interview, it took another 2 years to adjudicate, right? And so it all depends on your case, but it's definitely it's hard to clearly predict how fast you'll be able to get your oath ceremony.
Do you like being an immigration lawyer?
I love it.
Yeah, I feel like you really do.
Yeah, it's. I mean, maybe I'll take this time to talk a little bit about why I love my job. I love learning new things, and as an immigration lawyer, I get to learn about family law, business law. I get to learn about politics and global politics that's happening all around the world every single day. News are always changing, and so it's never a dull day. And I don't like to do the same thing every single day, and so constantly learning new things is really exciting for me. I like to help people immediately, right? My original goal is to be a professor, but changing the world through educating the youth is a little bit too slow for me. But these cases, right? New information, immediately address it, prepare it, solve it, win it. Sometimes it can happen in a day, a week, even a month, right? Other type of litigation lawyer work, sometimes you take a decade to fight one case. Whereas this, it's like every day we're seeing things change. So these are some of the top reasons why I love being an immigration attorney. Get to help people, get to learn new things, and I think is extremely relevant. And I feel like I'm making the world a better place.
Wholesome. Is having a doctorate degree automatically qualified to be NIW?
Nope, not at all. Not NIW, not EB1A. USCIS pushes back on this a lot. They say with a pompous attitude, we have the best doctors in the US, why do we need you, right? I've seen that almost verbatim. So you still have to make the argument why you are useful to the US. Now, if you have a license in the US, you were educated in the US, you're able to practice in the US, and the US has a dire need, that makes it a much stronger argument, but not even guaranteed, right? Like we had another client that won the Emmys, still had to prove why he was extraordinary, right? And so don't assume the officer understands.
Yeah, I'm not sure why some comments aren't visible to me. So I'm sorry about that if we have missed any comments. Try saying them again, and maybe they will show up. But for now, I do want to get into the success story for today.
Yes.
And then if we have time after, we'll go back to some questions. So what are we talking about today?
So today's success story is about a O1 applicant, an O1 extraordinary ability non-immigrant visa. The client was he graduated from a master's degree, got accepted into a PhD, but wanted to work and don't want to study that much anymore, right? And so he already got his bachelor's, got his master's, in the process of PhD, but wanted to work. And him and his friend have a company and want to see if they can work and immediately get his life started. So we filed the O1, got approved, and the same application actually qualified him for an EB1A as well. And so the question becomes, well, how can this student qualify to be an extraordinary O1 computer scientist? Right. And so I want to go through the details of the case so most people can directly compare, oh, do I have the similar things as this O1 applicant? And also, after we do that, we'll talk a little bit about, well, how can you still get an O1 even if you already have an EB1A, or vice versa? How do you go from O1 to an EB1A, right? And so the dual intent thing is very, very important. But let's get into it first. I have to do this because I don't want to accidentally show the client's info. And shoot, it's double-sided printing. Darn it. All right.
Yeah. This is...
Okay. Well, you can't see anything there, right? Okay. Well, okay. I'll just go off of memory then. We argued. It was a 27-page attorney brief. The first 10 pages is really talking about the client's background, the company's background, what the client is going to do in the US. And the company was an IT company. It solves computer IT problems. And he is a computer scientist, and he got his bachelor's in it, he got his master's in it, and he's getting his PhD in computer science. And he is really good at Microsoft, like really good at it, because he ran competitions for it. He was involved with a lot of organizations, even during his student years back in his home country and while in the US, to really push for the advancement of Microsoft Word, etc. And you're like, wow, that qualifies for O1 extraordinary ability? How? The argument is that as a computer scientist, and he's creating this program that can help solve cybersecurity. Microsoft is a really big company. He's really good at Excel. He's really good at Microsoft Word. He's published books on it, and he led organizations that pushes the frontier of this particular software. And he's going to use that skill to help this IT company to solve cybersecurity. You might think it's a stretch. I don't understand computer as much as this client and other people, but he got a lot of letter recs. He got it. I mean, after all, he is in the PhD program, right? And so, essentially, we start by saying, Microsoft Word is just that powerful. It can even solve cybersecurity. Not in those exact words, but that's a concept of it. So we were able to prove that this company, he was going to be the chief technology officer of this company. And he's going to change from a master's degree, now going to this company to be the CTO, to work on these particular programs. And it's going to solve these IT problems and cybersecurity. And we argue that 99% of the companies in the US are all small to medium-sized, small mom-and-pop companies that don't have the funds to fight cybersecurity like the big corporations, and they're all very vulnerable, and that's what this company is aimed at doing, right? And so we spent a lot of time thinking it through the business plan with the co-founder. We prepared it, and that was the first 10 pages of this brief, where we argued that this client, with a master's degree, is going to solve that problem as a CTO, and this is the business plan, this is what he's going to do. And then the next 17 pages, we argued 5 areas of his extraordinary ability on why he qualifies for the O1. And these same 5 criteria is what we used with the EB1, and both got approved. It was publication. He was able to publish like 2 books. We argue that it was the best in class. A lot of citations on it. He was a part of a lot of student unions. We argued judgeship, where he was a judge for the Microsoft, competition, and leading critical role. We didn't argue high salary. Which one? What else did we argue? We argued leading critical role, authorship, original contribution, awards, and he was a judge of others, right? And so because he was able to do the awards in the Microsoft competition, he was able to win his accolades, and we were able to tie it to his business plan to show that he is a extraordinary scientist in the computer science world. Now, was this a slam dunk case? I wouldn't say so. There were concerns, right? A lot of his judgeship was while he was being a student at the student competitions. His awards, again, related to his student, activities. His critical role was during his part of the projects that he worked on while being a student for the companies that he worked for. Think of it like an intern, working on certain projects that made a big difference for the company. But is it a critical role? A lot of these arguments were somewhat weak. It met the requirements, but it didn't make any officer feel like this is outstanding. But when you compare him to other just normal students, most students just get good grades if you're a good student, but he did above and beyond all the other students, and he got a lot of letter recs. And so filing the O1, we thought it was fine, but it also qualified him for EB1A. And so with that as a reference, this case just got approved, I think the end of 2025. It's been a big delay. There's so many things that happened, but we filed it in, August of 2025, got approved shortly thereafter, and now waiting for priority date to adjust status, right? And so it's a very interesting concept, but I think one of the more interesting thing is talking about dual intent, especially nowadays, right? Because of the memo, because of the May 22nd memo talking about why did you adjust status in the US, a lot of people are now worried, well, I don't want to come in as a tourist visa to adjust status anymore because they might force me to leave. It's much better to get a visa that allows dual intent. And there's only so many. There's the H visa, but if you're applying for overseas, you might have to pay the 100,000 fee to the government. Or if you do the L visa, but not everybody's a manager or executive overseas for over a year. Maybe they're still a student. So for a lot of students, whether in the US or overseas, one of the only ways to get in and then to adjust status later on might be the O1 visa. Now, why is the O1 a quasi, semi dual intent category? Because it's right in between. Unlike the B1, F1, and other visa categories, under the Foreign Affairs Manual, under the guidelines of O1, the consular officer cannot deny the case just because they lack home ties. All the other categories, you're supposed to prove you're going to come back to the home country. That is part of your application. That's part of what you need to prove. The O1, you don't need to. And it is highly discouraged to deny them based on immigrant intent. So even if you have an I-130, I-140 approved, you're not really supposed to be denying them on the O1 for that. So that's almost like dual intent. But unlike the H and the L, where it explicitly says that you can have dual intent, O1, you are not supposed to. So it makes it into a very interesting scenario, which we tell almost all of our clients. If you have an I-130, I-140 approved, or you're in the process of applying, or you've applied, got denied, and you're going to apply again, when you apply for the O1, your explanation is, my intent now is to do my project, my business, my job, and then the green card thing is in the future, right? I may or may not do it, but at least my intent now in the US during this time period, the next 3 years, is to do this X, Y, and Z thing. You don't have to prove home ties. You don't have to prove you're going to go back to your home country. That's all you need to prove. And so far, we've seen cases be successful, but just want to share this success story with you, right? A student who did a lot of great internships while being in school back in the home country as well as in the US, and got things published and ran these student competitions, was able to do an O1 and also an EB1, and now is ready for adjustment of status. We, I think, included like 8 letter recs. We argued 5 categories, but not all of them were extremely, strong. Didn't have high salary. Not every O1 requires that. And again, it's a friend startup, tech company. solving cybersecurity, greatly needed in the US, matches background. So there you go, right? Like, not every case is as crazy as you think, and not every case that we think is weak gets denied, and every case that gets weak is absolutely barred from approval, right? And so this case was like, it's hard, but we still spent the time to prepare it, and the client was able to win it. So glad to share this story with you. If you guys have any questions, feel free to reach out. It was Andy's team that did this case, Andy and Alan. And so if you want to book a consultation, feel free to contact them as well. Very proud of them. It was a good case.
Okay, we'll answer one more question. I'm sorry, Makeup Girly, we can't check our DMs on live. I just don't think we can do it at the same time. We will, at the very least, talk about it next time, and we'll try to get back to you over DMs. Okay, last question. What is the price to take over the case I filed? AOS B1, B2 overstay for 60 days, married to a military USC, spouse are expecting a baby in August.
Great. Well, we at least can help you through a consultation. You can book our consultations on our website, $250. You pay with credit card, and we'll jump in and we'll analyze your case. We'll give you a lot of feedback as if it's our own case. We try to do that to help as many people as possible. You might not need us to take over, right? Because there might not be anything that's needed because you already filed it. But if you get a request for evidence, if you get annoyed, if you get an interview and you really want us to strategize and mock interview and help, again, the consultation is the best way to help. But if there's some critical reason that you need us to take over now, during the consultation, we'll discuss it and then we'll quote you a fee. Again, the purpose of the consultation is not a sales call. We're just really trying to help. And again, for a lot of cases, we shadow counsel for a lot of people, right? You already have your own firm. Switching might be too expensive. We just help you with a strategy, and then you continue and you get case approved, and that's totally fine, right? We're very, very happy to do that. Even if you want to link your attorney with us and we can help them help you, we do that also, right? A lot of times we're all in the same chat group anyways. We go to the same conferences. They're colleagues of mine in different situations. So there's so many ways that we can help. The 250 consultation is the best way that we can immediately start. And again, it's just switching firms doesn't necessarily improve your case immediately, right? So hopefully that helps. And again, we have a lot of people at the firm, and they all can help you in different ways. And we try to set up our consultation so that we can help that many people as fast as possible. But because of that, the consultation is not going to be with me immediately, right? So if you only want to talk with me, you have to book it and you have to put in the memo, I only want to talk with Joseph. But again, if it's urgent, plenty of people here are really, really good. Okay?
Okay, that is our time. Thank you, Makeup Girly. We will get back to you in the DMs. I see that your deadline is coming up, so we will get back to you. But yeah, thank you, everyone.
Take care. Bye-bye.